afternoon, dear colleagues and guests. Let me declare open a session of the Dissertation Council for the defense of thesis by Akimov, Nikolay, Andreyevich for the degree of Candidate of Law, Specialty 12-0007, Corporate Law, Competition Law, and Energy Law, on the theme, the legal regulation of corporate governance in partly state-owned energy companies. With the order of St. Petersburg University of the 25th of August 2020, number 7398/1, me, Makarova Olga Alexandrovna, Doctor of Law, Associate Professor of the Department of Commercial Law of St. Petersburg University, was appointed Chairman of this Dissertation Council. Other members of the Dissertation Council were appointed by the same order. Before I introduce them to you, I would like to call a technical break for 5 minutes, since it is necessary to establish connection with a member of the Dissertation Council. I announce a technical break for 5 minutes. Dr. Heffron, can you hear us? Dr. Heffron?
Yeah.
Okay.
Yes.
All right. Thank you. Thanks.
Розна Елена, вы нас слышите? Да, у вас выключен микрофон.
We are on a technical break for 5 minutes. Dear colleagues, let us resume the session of our Dissertation Council. Let me introduce members of the Dissertation Council. Papandopoulou Vladimir Fedorovich, Doctor of Legal Sciences, Professor, Head of the Commercial Law Department of St. Petersburg University. In remote access mode, Vladimir Fedorovich, can you see and hear us? Yes, I can see and hear you. Thank you. In the remote access mode also, we have Saliva Rosa Nailevna, Doctor of Law, Professor, Head of the Laboratory Legal Ecology and Fuel and Energy Complex of the Institute of Problems of the Ecology and Use of Mineral Resources of the Academy of Sciences of the Republic of Tatarstan, Rosa Nailevna. Can you see and hear us? We are really glad to see and hear you. Yes, I can see and hear you very well. Thank you. So please do not disappear. Okay. Shevchenko Lyubov Ivanovna, Doctor of Law, Professor, Honored Lawyer of the Russian Federation, Professor of the Department of Legal Regulations of the Moscow State Institute of International Relations of the Ministry of Foreign Affairs of the Russian Federation. Lyubov Ivanovna, can you see? Can you hear us? Yes, all is well, thank you. Dr. Kim Patrick Talus, University of Eastern Finland. Unfortunately, he could not join us today. Dr. Raphael Heffron, University of Dundee, United Kingdom. Dr. Heffron, can you see? Can you hear us?
Yes, I can. Yeah. Thank you.
Thank you.
The degree applicant, Akimov Nikolay Andreyevich, is also present. Also, his academic advisor, Romanova Victoria Valerievna, Doctor of Law, Head of the Department of the Energy Law of Kutatin Moscow State University of Law, is present. To improve the quality of communication, I invite you, dear colleagues, working in the remote access mode, to switch your microphones off, but please remember to switch them on when you are given the floor. Let me also inform you that our session is being recorded and broadcast online at St. Petersburg University website. The speeches are being simultaneously translated from Russian into English or from English into Russian. During the live broadcast of the session of the Dissertation Council, an email address is currently displayed to which all the listeners during the session can send their opinions and send questions to the degree applicant online regarding his thesis and the ongoing scientific discussion of his presentation. These questions shall be forwarded to me by our technical support, and I shall read them during the discussion. Questions should be related strictly to the applicant's presentation and his thesis, and include the name, place of employment and position of the author. Questions that are not related to the scientific discussion of the thesis, the text and evaluation of the thesis itself shall not be presented. In accordance with the order of awarding academic degree of Candidate of Sciences and Doctor of Sciences at Petersburg University approved by the local regulations of St. Petersburg University, a session of the Dissertation Council shall be considered competent if at least 2/3 of the approved members are present, but not less than 4 persons. Our Dissertation Council consists of 6 persons. 5 are present, including 4 council members in the remote interactive mode. Audio-visual contact has been established with all the council members. Thus, we have the quorum. Let me set forth the procedure of today's session of the Dissertation Council with the approximate duration of 2 hours. 1. Summary report of the chairman on documents submitted by the degree applicant and their compliance with the applicable regulations. Answers to possible questions, approximately 5 minutes. Degree applicant's summary report outlining the key points of his study approximately 15 minutes. Questions to the degree applicant strictly on his report, no more than 2 minutes per each question. Answers of the applicant, no more than 5 minutes for all questions. Speeches of all members of the Dissertation Council in turn, with their assessment of the thesis and the applicant's presentation, with a summary of their positions, questions and suggestions to the applicant, approximately 10 minutes for each speaker. Speech of the chairman with his assessment of the thesis, approximately 10 minutes. Answers of the degree applicant to questions and comments of the council members, 20 minutes. Open discussions, speeches of persons present at the session, with summary of the opinions and specific questions and suggestions to the author. No more than 2 minutes for each speaker. At that, all those willing to speak are kindly requested to register themselves in the registration sheet and introduce themselves fully before speaking. Presentation of questions to the applicant sent during the discussion and of his speech and the scientific discussion via St. Petersburg University website, and answers of the applicant, no more than 2 minutes. Speech of the academic advisor, no more than 3 minutes. Discussion by the members of the Dissertation Council before the open voting of the defense results. For this period, sound shall be switched off. Open individual voting. Votes shall be counted by the chairman, and the results should be recorded in the minutes of the meeting. Making decision on awarding or not awarding academic degree. And closing remarks of the applicant, no more than 2 minutes. Dear colleagues, do you have questions or objections to this procedure? If you have no objections, let us start this session. Please remember to switch off your mobile phones. And let us start. First of all, my summary report. A thesis by Akimov, Nikolay Andreyevich, for the degree of candidate of legal sciences. Specialty 120007, corporate law, competition law, and energy law, on the theme legal regulation of the corporate governance in partly state-owned energy companies, was accepted for defense by the order of Academic Secretary of St. Petersburg University of the 20th of August 2020, number 7349/1. Akimov Nikolay Andreyevich wrote his thesis at Kutafin, Moscow State University of Law, under the guidance of Doctor of Law, Head of the Department of Energy Law of Kutafin, Moscow State University of Law, Romanova Victoria Valerievna. Number of publications of the applicant which set forth the main findings of his research according to the enclosed list is 5. In peer-reviewed journals from the list approved by the Ministry of Education of Russian Federation, 5 publications. In journals indexed in the scientometric databases Web of Science and Scopus, no publications. The applicant submitted to the Academic Secretary of St. Petersburg University a full set of documents for acceptance of his thesis for consideration and defense. All the documents comply with Article 12, Section 3 of the order. All the documents submitted by the applicant, according to the information I received from the curator, comply with the requirements and are kept in the applicant's attestation file. Copies are available from the officer of the Dissertation Council Activity Support Department, who is now present. Before I give the floor to the degree applicant, do you, dear council members, have any general questions to the applicant? And is it necessary to read and review the entire list of documents submitted by the degree applicant? If there are no questions, let us proceed to the next point, the applicant's summary report. Nikolay Andreyevich, the floor is yours. You have 15 minutes for your presentation. Thank you for giving the floor to me. Dear Chairman, dear members of the Dissertation Council, The thesis presented to your attention is dedicated to legal support of corporate governance in companies with state participation in the energy sector. Speaking of relevance, the proper level of legal support of corporate governance in energy companies has a direct impact on the activities of these subjects, which in turn depends on sustainable and effective development of the energy sector, one of the fundamental sectors of the Russian economy. Proceeds from the activities of such companies form a significant part of the federal budget of the Russian Federation. In this regard, it seems obvious that gaps and uncertainties in the legal regulation of corporate governance in companies with state ownership in the energy sector may have a negative impact on the efficiency of such companies, as well as on the development of the energy sector and the national economy in general. The purpose of my thesis is to develop theoretical provisions on peculiarities of legal position of the companies with state participation in the sphere of energy, study of foreign experience and legal regulation of corporate governance, comparative legal analysis of corporate governance models emerging in the nuclear and gas industries, as well as formulation of proposals on unification of legal norms regulating corporate governance in companies with state participation in the sphere of energy. Scientific novelty of the thesis is that for the first time in theory of energy law, a comprehensive analysis of legal support for the corporate governance with state participation in the energy sector was carried out, and peculiarities of legal status of such companies and its participants in the corporate relations were revealed. Let me elaborate on some of the proposed provisions in more detail. First, within the framework of analysis of legal nature of relations formed in connection with the implementation of corporate governance in the sphere of energy, the author's definition of a company with state ownership in the sphere of energy was formulated as a legal entity with special objectives of activity realized in the sphere of energy, the share of participation of which directly or indirectly belongs to the state, which gives the state the right to receive part of the profit from activity of such legal entity, as well as the right to participate in the corporate governance. The key element of legal status of companies with state participation in energy is a set of special goals of activity of such companies, combining both interests of profit-making and socially significant interests on satisfaction of public needs in those spheres of activity where independent participation of private investors is not possible. Second, the results of analysis of source of legal regulation of corporate governance if companies partly owned by the state and the energy sector lead to the conclusion that it's necessary to unify the provisions on corporate governance of these companies. In order to approve legal regulations and increase the efficiency of corporate governance, it seems reasonable to unify the provisions of corporate governance in the companies by the federal law that would principles of corporate governance, special rights of corporate governance, provisions on execution of certain types of transactions, and local regulation and internal control. 3. Basic principles of corporate governance in companies with state ownership in the energy sector have been formulated, such as principle of ensuring implementation of effective corporate governance, principle of observing the balance of interests in the state and private participants, principle of proper disclosure of information, principle of professional presence in the company management bodies, principle of responsibility sharing between members of the management bodies and controlling persons. Special corporate rights of the participants of legal relations formed in companies with state ownership in the energy sector have been determined. Special corporate rights are understood as rights, the existence of which are typical for participants of corporate relations in this energy sector and reflect specific features of such companies. Within the framework of this unification, we propose to vest the following special rights: the right of the company with sole participation to be a founder of another company with sole participation, the right for normative legal regulation in the sphere of energy, special rights of the state when making decisions on certain issues, the right to receive complete and reliable information about the company's activity. 5. We propose to unify the provisions for certain types of transactions of companies with state ownership in the energy sector. Taking into account the strategic importance of energy resources as well as the need for additional security of energy facilities, we propose to remove the legal regulation of certain types of transactions by companies with state participation from the general regime established by corporate legislation. Within the framework of preparation of the project to unify the federal law, We propose to provide the committees on coordination of transactions within the structure management bodies of such companies using the experience of foreign legal regulations. 6. Necessity to provide all-round internal control of the activity of managerial bodies of companies with state ownership is grounded. Internal control directly influences efficiency of corporate governance and allows for independent assessment of activities and timely establishment of facts of their unlawful behavior without disclosing confidential or any other undesirable information about the company's activity. As part of the formation of unified provisions on corporate governance in companies with state ownership in the energy sector, we propose to establish unified requirements on obligatory formation of an internal control body in the companies under consideration, to establish qualification requirements for the persons, members of such body, and to ensure that such persons have measures to prevent conflict of interests. 7. There's a gap in the current legal regulation in terms of absence of special requirements to disclosure about local that cover an undefined circle of subjects. As a result of this gap in the legal regulation, there's a problem connected with the lack of access to actual norms of the company's local regulations. For the purpose of further development of legal regulation, it seems expedient to consolidate at the level of the federal law the provisions on the register of local acts of companies with state ownership in the energy sector, containing records on local regulatory acts, the dates of their beginning and termination. We propose to transfer the powers to the information disclosure and activity of companies with state participation in the sphere of energy to a state agency for this purpose. 8. Current legal regulation has a gap in terms of requirements to the composition of supervisory board of Rosatom due to lack of established quotas for participation in this body by representatives of various government agencies and public organizations. In order to ensure guaranteed representation, we propose to amend Article 23 of the federal law on the State Atomic and Nuclear Energy Corporation and to establish a mechanism similar to the mechanism established for the formation of supervisory board on Market Council. Paragraph 4, Article 33 of the Federal Law on Energy Sector. Guaranteed participation of various authorities and public organizations in the work of the corporation will allow additional balance of interests for the participants of legal relations of this supreme managerial body in the key nuclear industry entity. 9. In order to identify peculiarities in the legal state of companies in the gas sector, we propose to classify such companies depending on the type of activity: companies engaged in exploration, production of energy resources, companies producing electric and thermal energy, companies for transportation, transmission, storage and distribution of energy resources, energy resource processing companies, security companies, and other companies consolidating non-core assets, social projects and media. 10. As a result of a comparative legal study of the corporate governance in companies with state ownership in gas industry, we identify peculiarities of the corporate governance model of such companies as compared to nuclear industry companies. The results of this legal study revealed the necessity to centralize corporate governance in the gas industry, which should be based on the model of corporate governance in the nuclear industry, where the leading role is played by the corporation with special powers to regulate relations emerging in this or that industry. Dear colleagues, to sum it up, I'd like to say that nowadays the issue of legal support of corporate governance in companies with state ownership in the energy sector needs further scientific consideration, including the tasks of improving the state and corporate governance in the energy sector, which are among the strategic tasks of the Russian energy sector for the period until 2035. The results of my study can be used for further study of legal problems arising in the process of corporate governance in companies with state ownership in the energy sector, in regulatory activities, law enforcement and training. My report is over. Thank you for your attention. Thank you very much, Nikolay Andreyevich. Dear council members, do you have any questions to the applicant at this point? Do you have questions? Any questions, please? And council members, dear council members, Dr. Talos has just joined us. Dr. Talos, can you hear us? Please say yes if you can hear us.
Yes. Can you hear me?
We need to decide if Dr. Talus will be able to vote.
Так, по процедуре, соответственно.
According to the procedure of St. Petersburg University, since Dr. Talus has just joined us, he'll be able to present his review, but he won't be able to participate in the voting on the results of our work. Dr. Talus, is that clear? Is the situation clear to you?
Yes.
Thank you. If no one has any questions to the degree applicant, Nikolay Andreyevich, please have a seat. We received an external review from the Director for Legal and Corporate Affairs and Property Complex of Rosatom State Energy Corporation, Popov Andrei Vladimirovich. Dear Council members, all the reviews have been published at St. Petersburg University website. So I suggest that you present only critical remarks and the key points related to points for discussion or remarks. If you have no objections to that, let us focus on the remarks only. The review by Andrey Vladimirovich Popov is positive. The author comments on relevance and novelty. The first question, in second provision set for protection, the author explains the need to unify the provisions on corporate governance in companies with state ownership in the energy sector, page 10. It will be interesting to know what he thinks, how the industry peculiarities will be taken into account in companies with state ownership. Second question, in provision number 8, set for protection, the author suggests to set quotas for participation in the advisory board of the state corporation Rosatom, similar to the advisory board of Market Council. The need to ensure balance of interests of social relations in the nuclear industry. It's interesting to know what the author thinks about the appropriateness of his proposal, considering the vested rights and responsibilities of various participants of social relations in the nuclear sphere and in the federal law. The questions are points for discussion and do not affect the overall positive impression and do not diminish the theoretical value of the work in question. Dr. Popov concludes that a thesis is a qualification study which contains solution to the scientific task set by the author, the energy law. The thesis by Akimov Nikolay Andreyevich on the theme legal regulation of the corporate governance in partly state-owned energy companies corresponds to the basic requirements set by the order on awarding academic degrees at St. Petersburg University, and the degree applicant Akimov Nikolay Andreyevich deserves awarding academic degree of candidate of law, specialty 12-0007, corporate law, competitive law, and energy law. Article 11 of the above-mentioned order has not been violated by the author. Dear Nikolay Andreyevich, how would you prefer to answer each reviewer individually, or will you take all the questions and remark in the end? I will answer all the questions in the end. Then I suggest the applicant to answer all the questions in the end. Now let us proceed to speeches of members of the Dissertation Council, and let me give the floor to Council member. Let me remind you that all the reviews have been published at the university website. So I suggest that we read only the key points, questions, and critical remarks to the thesis. I'd like to give the floor to Dimitrios Papandopoulou. Dear Chairman of the Dissertation Council, dear members of the Dissertation Council, dear author, dear colleagues, I will follow the suggestion of the chairman, and I will only focus on the critical part of my review, meaning that the full review is available at the university website. Yet I'd like to say that the theme is relevant, as well as its corporate components, the energy sector. This is also evident because these issues draw attention of researchers. Many researchers are writing about this, but as the author says, there is still a need to improve legislation. I'd like to say that some provisions, maybe most provisions, are of organizational, technical nature, which is interesting. For example, the suggestion to create a registry which will make them available, but I think this is not immediately connected with the legal theme, so I shall leave out these points. I think the most questionable conclusion or theoretical conclusion that can start a discussion is the definition of companies with state ownership in the energy sector made by the author. Let me remind you that a company partly owned by the state in the energy sector is defined as a legal entity with special purposes of activity in the energy sector, a share of which belongs to the state, owned by the state, which provides to the state the right to obtain profit from its activities and participate in the corporate governance of such legal entity. The key element, says the author, the key element of the legal status of the company is a combination of special purposes or functions of such companies which combine an interest to get profit and socially significant interests to maintain balance of production, where participation of private investors seems impossible. In this definition, there are many things which I take critically. First of all, speaking of special goals of activity of companies partly owned by the state, I think there is doesn't have any special capacity. Such companies don't have any special capacity, because any commercial organization, by definition, they are legal agents. Then I'd like to ask, what's the legal significance of identifying such companies added, saying that such companies have special goal in their activity. This remained a mystery to me. Next, what does the author mean when he says that the state owns a share in a company in the energy sector that belongs to it as property? There is a discussion, there's a discussion on corporate property, which is not the theme of this thesis, but the corporate relations. These are relations with governed as written in Article 2 of the Civil Code. So if we are talking about some economic aspect, so then we get what is the legal significance of this? And my third question or comment with the also connected with the definition of a company in the energy sector. It is not clear the provision that such companies conduct activities in spheres where participation of private investors is not possible. I beg your pardon, but for example, some shares of Gazprom belong to private investors. There is proposal to distinguish between infrastructure companies, generation companies, processing companies, which at the moment belongs to monopolies. Isn't there a need to attract private investors? So the state doesn't know what additional forms of contracting. So there will be new form of contracts that will promote investment in addition to many well-known contracts or special investment contracts, concession agreements, etc. So here I think that, of course, to some degree, the provisions that I would like to criticize, maybe the author means something which is probably true, but the wording maybe are not good. The definitions maybe, the definition of a company partly owned by the state in question and its features result in these questions. But speaking of the thesis in general and of research conducted by Nikolay Andreyevich, I would like to conclude that this is an independent scientific study, work, and most conclusions and suggestions made by the author are well grounded, and normally you don't expect very deep scientific, unlike in doctoral thesis, you don't expect very sophisticated conclusions, but on a level of practical suggestions, this thesis has enough of those, which emphasizes the theoretical significance and the practical significance, and of course allows us to say that the critical remarks I've given do not affect the positive assessment of the thesis. I think the thesis by Nikolay Andreyevich Akimov, Legal Regulation of Corporate Governance of Partly State-Owned Energy Companies, corresponds to the requirements applied to such works by the order of awarding academic degrees at St. Petersburg University, and its author, Akimov Nikolay Andreyevich, deserves awarding degree of Candidate of Legal Sciences, Specialty 12.000, Corporate Law, Competitive Law, and Energy Law. Thank you for your attention.
Спасибо большое, Владимир Федорович.
Thank you, Vladimir Fyodorovich. I'd like to give the floor to Saliva Rosa Nailevna. Rosa Nailevna, the floor is yours. Thank you. Good afternoon, dear colleagues. I will follow the recommendations given earlier. I will not focus on general characteristics of the thesis. One thing I'd like to say is about relevance of the theme chosen by the author. Indeed, in modern times, companies in the energy companies acting in the energy market, which are partly owned by the state, such companies have a social function, and indeed it is necessary in the corporate governance to find a balance between business interests of obtaining profit and the social or state public interests that should be supported, and the state has some interest. I mean that companies partly owned by the state, their objective alone with profit is participation of the state in its governance. And the author, this balance, describes the balance in his work, and his suggestions and provisions set for defense have practical significance in the sphere of corporate governance, and they can be used. And in general, the work indeed deserves support because it addresses relevant task of today, optimal corporate governance that would take into account business interests and social interests. And while I support the work in general, it is necessary to say that, as any other research paper, it has some advantages and some points for discussion, of course. And as points for discussion, I would like to focus on some questions. And let me read them now. These questions about separate provisions. So one of the questions is about the object of the study. In provision 6, the author suggests to set universal requirements internal control for companies partly owned by the state, and qualification requirements for members of such bodies. But if we analyze this proposal in detail, you want to clarify something. How appropriate will it be to include this requirement in the federal law? And also you wonder if these requirements will be applied only to companies partly owned by the state or to other entities of law. This is one point. Provision 7, the author explains the need for information disclosure on internal legal acts of the companies, because it is necessary to ensure the balance of interests So here it is interesting what the author thinks, how such requirement should it be applied only to companies partly owned by the state in the energy sector? Or is this a general issue for all corporate entities, or only for the group of companies in the energy sector? Also, I like to clarify the following point. Provision 10, where the author suggests to develop governance and base it on the corporate governance model of nuclear sector companies, where the leading role is played by corporation, which has special authority in legal regulations. So here I wonder, the example with energy sector, of course, is appropriate, and we need to discuss this, but is this the legal form? Does it allow us to implement these requirements, apply these requirements to the company in the gas sector? And will the change of organizational form of this subject make it less attractive for investors? Here it's necessary to consider other points connected with conducting business in this sphere, and will the economic stability be endangered by such a move in the gas sector? And maybe one more point connected with the object of the study and conclusions made by the author in the end of his paper. As the object of his study, the author mentions social relations in corporate governance in companies partly owned by the state in the energy sector. At the same time, in his work, he is given examples not of all companies in different energy sectors, because when we talk about the energy sector in a broad sense, we talk about legal regulation in regulations in generals in different spheres, including gas, oil, coal, electricity. And so here I'd like to ask why according to the author, what are the peculiarities of corporate governance, for example, in oil companies partly owned by the state as compared with other energy companies, or the suggestions made on the example of gas companies. These rules or these conclusions can be applied to all energy companies. So what does the author think? So it will be interesting to know this, but in general, these discussion points do not affect my positive assessment of the work conducted by the author, and do not diminish the theoretical and practical significance of this thesis. And I would like to say that in general the thesis by Nikolay Andreyevich Akimov on the theme Legal Regulation of the Corporate Governance in partly state-owned energy companies corresponds to the basic requirements set by the order of St. Petersburg University, and the degree applicant Nikolay Andreyevich Akimov deserves awarding the degree of Candidate of Legal Sciences, Specialty 120007, Corporate Law, Competitive Law, and Energy Law. Thank you. Thank you very much, Rosa Nailevna. I would like to give the floor to Doctor of Law, Professor Shevchenko Lyubov Ivanovna. Dear colleagues, my review to Akimov Nikolay Andreyevich on legal regulation of corporate governance in partly state-owned energy companies. And in my review, I mention relevance of the theme. This theme is relevant not only because it is necessary to study the energy strategy of Russian Federation, but scientific literature also indicates that some aspects connected with the activity of such entities should be analyzed and improve in this regard of the regulatory documents of such entities. And I wouldn't say that no one has explored this theme before. Of course, a number of researchers addressed this theme before and paid their attention to this theme. But what I liked about this thesis is that the author of this thesis somehow provides comprehensive analysis of all the problems and makes some suggestions for improvement of legislation on applicable to legal entities partly owned by the state and their functioning on the energy market. And separate, he explored such legal entities in the nuclear industry and gas industries. And of course, in my review, I analyzed the contents of the thesis, validity of the scientific provisions made by the author, and validity and novelty of provisions and conclusions, provisions which the author included in the conclusion, and the most important ones he set for defense. I consider all these provisions, scientific provisions, have been properly proven. They serve the tasks of the study and reflect the scientific and theoretical significance of the work. It's also important that the author uses legislation of foreign companies such as France and China, and used the analysis to maybe to obtain his own conclusions, which he set for defense. Of course, the provision, I'd like to praise a first provision where the author tries to give his own definition of a company partly owned by the state in the energy sector, where he explains the key elements of the legal composition of such companies. The criticism already we heard from Professor Pandopoulos already. The second provision is also of interest, And second provision, where the author explains the need for unification of corporate governance in companies partly owned by the state in the energy sector. This provision indeed has some novelty because no one has taken even the initial steps. The third provision is also of interest. It sets forth the key principles of corporate governance of companies partly owned by the state in the energy sector. The principles he mentioned in his speech and those mentioned by other researchers will become the basis for further. They will be elaborated in the provision number 7. The author explains the need to ensure access to local regulatory acts. Such access is not easy, and not always local legal acts of such subjects entering into transactions. So the suggestion to establish such a mechanism to ensuring access is interesting, and I think will be elaborated by other researchers in the future. It seems to me that some provisions set for defense require maybe some clarification connected with their implementation. For example, second provision set for defense. The author makes some suggestion on unification of corporate governance with companies partly owned by the state and the energy sector. Here, how within a single framework of legal regulation, peculiarities of different subjects, of different energy sectors. I think this question has already been asked by the first reviewer. In the fifth provision set for defense, the author suggests to make legal regulation of different types of transactions in companies partly owned by the state not subject to general requirements of the corporate legislation. How some types of transactions require special legal regulation. Finally, in the seventh provision set for defense, the author suggests to provide access to information about the local legal acts of companies partly owned by the state. Here, I'd like to know which local legal acts of companies partly owned by the state will be included in such a register. Of course, these questions should be seen as points for discussion, and that is why I'd like to know what the author thinks and give his clarifications. I'd like to see that many works in this sphere, of industry are relevant because they enable us to understand better the energy legislation. So these are relevant issues we need to deal with, and partly so these issues serve to achieve the common goal, how we'd like to see what we want the energy legislation to be. I think that some steps have been taken by Akimov Nikolay Andreyevich in his thesis aimed at identification of legal regulation of corporate governance in partly state-owned energy companies. And so let me proceed to the conclusion that this work corresponds to the general requirements and specific requirements set by St. Petersburg University by the order of 2016 on awarding academic degrees at St. Petersburg University. I believe that considering the contents of the work, provisions set for defense, and the work performed by the author, and publications in leading journals, he deserves awarding, he should be awarded the degree of law specialty 120007. Thank you. Thank you, Lubov Ivanovna. I would like to give the floor to Dr. Kim Patrick Taulus. The floor is yours. Dr. Taulus.
Thank you. Thank you very much for involving me in this process and giving me the ability to and the possibility to read the candidate's thesis. I've learned a lot, and the interesting angle to me is that it looks at similar issues that you see discussed at an international level from a Russian perspective. And that has provided me a rare opportunity to see the same discussion from a very different type of angle. I'll start with the conclusion. It's a robust thesis. It has solid conclusions, and therefore it clearly meets the requirements of the university for the degree. However, of course, as an examiner, my role is to give critical remarks or ask critical questions. And those questions do not take away the value of the thesis. It simply is my role to raise these questions. And I have two specific questions. To me, it seems that the thesis is influenced by an idea that state ownership and significant state participation in the energy sector is necessary in order to ensure security of energy supply. This background starting point seems to influence a lot of the discussion in the thesis. And to me, that's a peculiar argument. There are certain merits to this argument, but then there are other aspects of this idea that I don't entirely agree with. My approach is influenced, of course, by my background and the European Union energy law or energy policy. And to me, state participation in energy companies is not necessary at all. As long as we are talking about the competitive segments of the energy industry. So anything from production of gas to sales of gas. In this area, I see the role of the government more as a regulator. And to me, those social objectives can be ensured by just external regulation rather than direct state participation. Now, the question of state participation in the infrastructure sector, in the non-competitive natural monopoly segment of the energy industry, specifically electricity networks and pipelines. There, I see the role of the state somehow differently, because in that sector, to me, the best owner of the assets is the owner that has an interest in developing the country or region as a whole. And here the social objectives are, of course, highly important. And in that sector, I would also agree that state participation is actually something that is very beneficial. But again, not necessary, but beneficial. So I think maybe a more nuanced approach to this question could be necessary. And I would like to ask whether the candidate agrees with this, or whether I have misunderstood the background argument. The second question relates to the comparative nature of the study. Now, comparative law is always difficult, and it's always open to criticism, unless you've lived in these countries for a very long time, in which case you understand the legal system and everything else about that country. But that's usually not possible. So when I'm looking at the thesis, it provides for comparative remarks based on a number of countries, but it really focuses, as mentioned earlier, on France and China. And my question to the candidate would be that, given that the surrounding legal and policy level environment in these countries compared to Russia is very, very different, do you think that the direct comparison in the corporate governance system and modalities of state participation works? In other words, have the differences in, for example, free and liberalized markets and then more state-controlled markets been sufficiently considered in the comparisons? And a related question would be, why was France and China selected as countries of comparison? I can see the value and I can see certain rationales for selecting these countries, but I would like to understand why the candidate selected those two specific examples to really focus on in the thesis. But with those questions, I do want to repeat that this is a robust, well-written thesis that has very clear structure, clear conclusions, and clearly meets the requirements of the university for the thesis. Thank you very much.
Thank you very much, Dr. Talos. Now, I would like to give the floor to Dr. Raphael Heffron. Welcome, Dr. Heffron.
Thank you. Are you able to hear me?
Yes, we can hear you. Yes, they can hear you.
Yes, thank you. So I will proceed, and I think the first thing to say is I acknowledge all the other comments of the examiner and that the report is available online. And I would hold that, a lot has been covered already, so I will try and narrow the focus to the key issues I mentioned in my report that have not been identified yet to date. So from my perspective, it is clear that, there is, let's say, a gap in the literature has been filled. There is a clear definition provided, or the advancement of a definition provided by the author within the context of principles of corporate governance for these energy companies, as well as the provision of case studies on nuclear and gas. I would acknowledge that semi-state companies, it is not just an issue faced in Russia at the moment, but I think it's an issue of importance all around the world. So I think some of the lessons from this research will be applicable to other foreign jurisdictions around the world. And it should be noted that in this time of COVID-19, there is also plans in many countries to ensure that some energy companies fall into this category even more so, and that there is a lot more public and private participation, joint participation in the energy sector. So I just had three major questions, let's say, for you to, you can address them obviously now, or, you know, there are things to address later on in terms of the PhD process. And the first is that you do provide some level of historical analysis, but my belief is that there is a need to go deeper into some of the historical analysis of this topic, and to fully assess, you know, what is it that is changing things at the moment. So why is the law in this area changing at the moment? And in my report, I do make reference to one paper which tracks those changes from an international perspective. And within that paper, there is further reference to works in literature from North America, which tracks changes in terms of why do things change, particularly for energy law companies in their respective jurisdictions. So it will be interesting to see on that evolutionary phase where you believe these changes, why these changes have become important to consider now in Russia. A second question, and maybe a comment in terms of the review of some of your work. You spend time focusing on principles, and again, I would refer to some work completed by a group of international scholars that focuses on a variety of principles of energy law specifically. And I thought that maybe there was some merit, considering that you had case studies, there was some merit to considering not only principles from a corporate governance perspective, but where would these principles in terms of corporate governance, how would they fit in terms of energy sector or energy law principles, and how would they fit in the context of those principles that have been defined. And maybe that's something to consider now, or maybe just something to reflect on afterwards. And I give the reference to that report. I'm not sure if you've had time to examine it. But it is worth recalling that from a national level in terms of energy law to an international level, that there is increasing reflection, in particular by international judiciary of different types, to look for more principle-based approaches. So it will be my belief that one needs to broaden out the discussion on principles to accommodate this. Then a final issue would be in terms of, I thought there maybe should be some reflection on the case studies, let's say, in terms of focused on nuclear energy and on gas, and just on the relationship between those case studies. So is there anything, nuclear energy learns from gas and vice versa? Is there anything gas learns from nuclear energy in terms of the key points, in terms of your contributions of your of the research, and in particular, let's say, in terms of proposition number 10, in that type of discussion. So I felt that there was a lot of very good work done in this context, but the relationship between maybe what the lessons learned, let's say, the lessons learned from gas and nuclear, and how they relate to each other, and would there be any potential for use in the let's call it the opposing sector. So they will be the main sort of comments to make in terms of my own report, and to differentiate from the previous examiners' discussion points. And I would conclude and reflect the other examiners in saying that, you know, the overall quality of the research was very good. And as I identified the different gaps and contributions at the outset of my speech, I would conclude that, you know, I would be satisfied that your research meets the requirements of the award of the degree at your university. So thank you very much.
Thank you very much. Thank you very much, Dr. Heffron. Let me, as the chairman, present my review. I also mention the relevance of the study, and I will not go into novelty and theoretical significance, but what I would like to say is that Nikolay Andreyevich succeeded to achieve his main goal, to demonstrate peculiarities of corporate governance in such countries where the state is a shareholder and has all the rights of a shareholder and may be involved in corporate governance, and on the other hand, as the bearer of public functions, it should administer its functions, and such dual position, dual responsibility of the state explains certain peculiarities in corporate governance of such companies in the energy sector, of course. So my general assessment of this work is positive, and of course I'd like to I have some questions and remarks. I appreciate the approach of the applicant, where he considers the legal status of state corporations and member companies, and the status of Gazprom and of other companies, where Gazprom and its daughter companies. And on one hand, of course, I would like to know why the author focuses on these companies, and I said in my review that it would be good to evaluate companies in the electricity sector, not only discuss companies in the nuclear sector and look at specific features of corporate governance would enrich your work and confirm the conclusions made by the author. But on the other hand, the exploration of state-owned companies which have a special status, and of joint stock companies, public joint stock company such as Gazprom, enabled the author to demonstrate the possibility of choice of an organizational form and how this form affects corporate governance. The second provision, to some degree, has already been discussed by Vladimir Fedorovich and Lubov Ivanovna. Maybe my wording is different. Speaking of the author's definition of a partly state-owned company, the author defines it in his thesis as a legal entity with special purposes implemented in the energy sector, where a share of it belongs to the state, which provides the state with the right to obtain profit from its activity and participate in the corporate governance. On pages 21-22 of the thesis, the author defines a partly state-owned company in the narrow and broad senses. And I have a question. Is the understanding company in a narrow and broad sense? Do such definitions contradict the author's understanding? And does the author see a fully state-owned company as a corporation or as a unitary entity? This is my first question. My second question is about provision 3, where the author lists principles of corporate governance in companies partly owned by the state and analyzes the concept of corporate governance, but does not provide his own definition. And in my opinion, it very much depends on what you mean by corporate governance in companies partly owned by the state. Then you may define the principles of corporate governance. So my question is, how the corporate governance principles in companies with state ownership mentioned by the author relate to the principles of the corporate governance code and of principles for companies partly owned by the state. My third comment is about provision 4, set for defense, where the author suggests best special corporate rights to companies in the energy sector, and he uses Gazprom as an example. My question is, will such special corporate rights belong only to joint stock companies and the role of the state to exercise corporate governance, or will such rights be vested to all the shareholders, including information disclosure? And my next comment is about local regulations. The author suggests to establish a special register of such regulations, but in some cases he's talking about local regulations and legislation. Am I right in thinking that local regulations are internal documents of corporations and legal acts are acts adopted by the state or by some state agency, and if the information in the local acts shouldn't be disclosed as prescribed by the central bank? So my last comment is the same as the comment made by external reviewer about the functions of advisory board of Rosatom, similar to the Market Council. I have a similar question, very similar to the question asked by Dr. Popov. That is why I will not talk about it. All these remarks are points, should be seen as points for discussion, and do not affect the overall positive assessment, and demonstrate some practical and theoretical significance of the issues discussed in this thesis. Thus, I'd like to conclude that this thesis is a scientific paper which solves its task and makes a contribution into corporate and energy law. The thesis by Akimov Nikolay Andreyevich, Legal Regulation of Corporate Governance in Partly State-Owned Energy Companies, corresponds to the basic requirements set on the 1st of September 2016 on awarding academic degrees at St. Petersburg University. And the author, Akimov Nikolay Andreyevich, deserves being awarded the degree of Candidate of Law, Specialty 120007, Corporate Law, Competitive Law, Energy Law. Article 11 of the above-mentioned order has not been violated. Thank you. Now that all the reviews have been presented, I would like to give the floor to Nikolay Andreyevich, and I would like him to answer questions. Nikolay Andreyevich, please remember you only have 20 minutes for this. Thank you for giving me the floor. Dear Chairman, dear members of the Dissertation Council, thank you for your feedback, recommendations, comments, and positive assessment of my work. Now I'd like to answer some questions included in your reviews. I'd like to start with questions asked by Rosanelda Saliva. First of all, I'd like to thank Dissertation Council member for her valuable feedback and positive assessment. Also, I'd like to thank her for her questions. As for the issue of experience of set requirements of obligatory formation of internal control bodies at the level of federal law, I'd like to say the thesis emphasizes special importance of internal control mechanisms for building an effective corporate governance system in companies with state participation in the energy, establishing requirements to the availability of internal control mechanism at the level of a unified federal law will legalize this mechanism as one of the basic for the purposes of implementation of effective corporate governance and additional protection of the rights of the state as a participant of corporate relations. Thus, it is advisable to fix these requirements at the level of a federal law, establishing same rules of corporate governance for companies under study. Since additional protection of state interests is one of the main tasks of corporate governance in companies partly owned by the state, and determines the specific features in this institution, it's advisable that the discussed requirements apply to companies with state participation in the energy sector. At the same time, other subjects of the energy law have the right to establish similar mechanisms for the purpose of increasing the efficiency of their activity as a result of proper management. Speaking of disclosure of information about local regulatory acts, first I'd like to thank the Council member for this interesting question. In the first provision of the thesis, I emphasized that the legal position of the companies with state participation is due to the presence of socially significant goals to maintain a balance of interests in certain spheres. And in general, activities of such companies have impact on a number of stakeholders, and local acts of such companies also serve as the basic for numerous subsidiaries and daughter companies. And here, local regulations get special significance. At the same time, the question may be the subject of further study in order to develop such legal regulation. The third question about in the gas sector. In my study, I found that specific features of legal position of the owner in a gas supply system provide the entity to make it possible to implement their tasks, including the need to maintain and develop the unified gas supply system. The tasks set forth are no less important than those set for the state Rosatom company. At the same time, the approach of such key entities is different. Successful implementation of Rosatom powers at the level of financing of its activities have led to the issues of using this model in the gas industry, as well as for the benefit of citizens of Russia. Second part, if the change of organizational form lead to make it less attractive to investors, I'd like to say that it's advisable to refer to the current indicators of investment attractiveness of entities in the nuclear industry. From public report of Rosatom for 2019, it follows that the corporation itself, as well as joint stock company Atomenergoprom, have high credit ratings and stable development forecasts. Public fundraising is carried out primarily through the placement of exchange-traded bonds, which have a high level of profitability and stability. In such circumstances, it's possible to predict that transition to different management model in the attractiveness will not suffer. And the peculiarities of corporate governance, all companies with state participation as compared to companies with state participation in other energy sectors, I'd like to say that corporate governance in this energy sector is not limited to gas and nuclear industries. That is why in the first chapter of the thesis, I pay attention to different types of companies with state participation in the energy sector. In second and third chapters, I consider governance models in companies, gas and nuclear industries, considering the fundamental differences in corporate governance. In energy companies have own peculiarities, which affect corporate governance and specific features, which can be a subject of further study. And in conclusion, I would like to thank Rozana Ilevna for her questions and positive assessment of my study. Next questions I'd like to answer. These are questions asked by Lyubov Ivanovna Shevchenko. As for the first questions, how the legal status will be taken into account, I'd like to say that such proposed unification justifies the experience of unified basic principles of corporate governance in companies with state participation. So I think the norms should be general. At the same time, industry specifics affecting the legal position of the subjects and peculiarities of corporate governance can be reflected in special norms vested both in the industry laws and local acts of the companies themselves. Speaking of types of transactions that require special legal regulation, I'd like to say that on the basis of my research, we can identify the following groups of the companies that require special regulation. The transactions beyond the normal business activities, extraordinary transactions, large transactions with related parties, transactions related to alienation and acquisition of certain types of property, important for the strategic development of the industry and state energy security. And finally, transactions related to transfer rights or shares and with state participation of separate energy companies. A question about local acts of companies with state participation expected to be included in the relevant register. I'd like to say that based on the degree of coverage of certain range of subjects, we propose to include the following groups of local regulations in the registry. Local acts regulating corporate relations, local acts regulating technical regulation, local acts regulating the procedure of concluding contracts, including by means of competitive methods, local acts regulated industry safety relations. Also, I'd like to thank Lyubov Ivanovna for her questions and positive review. Next, I'd like to thank Dr. Kim Taulus, member of the Council, for his positive feedback as well as valuable references and recommendations on the possible structuring of my study. As for the question of choosing the French and Chinese models of corporate governance, in the third paragraph of the first chapter, this choice is explained by the scale of activity of companies operating within these models. The scale is comparable to that of relevant Russian companies. Thus, I deal with management model of the French nuclear industry, the importance of which is extremely high, both for the French economy and for the state energy supply system. The choice of corporate governance system for the gas industry in China also took into account the scale activities of the key subject, Petro-China. Also, I'd like to thank Dr. Heffron, a member of the Dissertation Council, for his positive feedback, valuable recommendations, and additional references in the field of energy law of foreign countries, which Dr. Heffron included in his review. Also, I'd like to thank the esteemed professor for his valuable advice on the design of research findings and references to foreign scientific literature. I'd like to say that when designing my work, I was guided by standard requirements for such types of work. At the same time, Dr. Heffron's advice on the possible structuring of the research is important to me, and I will take them into account when conducting further scientific research. Thank you. Also, I would like to thank the Dissertation Council member Vladimir Fedorovich Papadopoulos for his positive review, valuable recommendations and questions. As for the issue of special purposes of activity in the first provision, I'd like to say that indeed we don't consider a special legal capacity. At the same time, identification of special purposes of activity as a sign of companies with state participation has a doctrinal meaning, since a legal entity with state participation, alone with the realization of commercial purposes, is a supply of public goods and carries out activities aimed at satisfaction of public needs in general, thus realizing socially significant tasks of the state. Thus, this attribute directly reflects the meaning of including the state as a shareholder in certain companies and recording the size of the state shareholding at the level of legislative acts. Now the question of what is meant when I claim that the state has a stake in the company owned by the state. I'd like to say that norms of special industry legislation directly indicate the right of ownership formed by the state in relation to this or that form of participation in the energy sector. For instance, the federal law on gas supply sets the minimum number of shareholders owned by Russian Federation in the unified gas supply system within the framework of the federal law on peculiarities of management, disposal of property and shares in nuclear energy. The owner also includes the shareholders' right, Clause 3, Part 3, Article 1. Thus, the feature of a company partly owned by the state in the field of energy reflects the state powers of the owner in relation to the shares in its participation in the companies under consideration, which implies, above all, the use of appropriate methods of right protection. As for the third question, provision, the companies with partly owned by the state in the energy sector carry out activities in spheres where participation of private investors is impossible. It's important to say that provision 1 indicates that it is impossible to independently participate for private investors in certain spheres of activity, but joint participation is still possible. The impossibility for independent participants is conditioned by the necessity of state control over strategic interests, defense capacity and security of the state, protection of morality and health. At the same time, legal literature recognizes that public interests in the framework of such activities are most effectively taken into account through state participation. At the same time, within the framework of implementation of such activity is not always required. In some spheres, mixed companies, the minimal participation is recorded, while the rest can be traded in the free market, including the capitalization of the company. Also, I'd like to thank Vladimir Fedorovich for his interesting questions and valuable recommendations. And finally, I'd like to thank Chairman of the Dissertation Council, Olga Alexandrovna Makarova, for positive assessment, valuable recommendations and questions. The first question is the same as the question asked by Rosa Nailevna, which I have already answered. So let me have other energy sectors. So I would like to proceed to the second question. Correlation of definition with the state in the narrow and wide sense with the definition of the company in the sphere of energy stated in proposition number 1. I'd like to say that definition I gave on pages 21-22 in broad and narrow sense are seen as general, which characterize same features as a state company partly owned by the state. At the same time, my definition of a company partly owned by the state in the energy sector takes into account the industry features and is private in relation to the general definition of companies partly owned by the state given on pages 22-21. And regarding the question about joint stock company with 100% state participation, is it a corporation or a unitary organization? Should be noted that a joint stock company with absolute participation is still considered corporate organization because of their formal compliance set of in Article 65 of the Civil. At the same time, the actual model of implementation and management of such joint stock companies is identical to the model of management of unitary companies, because the will of sole shareholder in such companies is determined by executive authority or state corporation by legal acts. Such deformation of the joint stock management model in joint stock companies with 100% state participation is of interest for further study, both in the field of corporation law and energy law. Speaking of the next question, a ratio of principles in provision number 3, code of central bank, and as well as corporate governance guidelines. I'd like to say that since the provisions of the corporate governance code recommended by the central bank are based on the corporate governance principles developed by the Organization for Economic Cooperation and Development, it's advisable to compare the principles with recommendations of the Central Bank of the Russian Federation. The principles of corporate governance set forth in the Corporate Governance Code contain the basic principles for development and improvement of the corporate governance in general. At the same time, it's proposed that the principles formulated in Regulation number 3 should be consolidated corporate governance provisions for special entities, companies with state participation in the energy sector. Thus, the principles of corporate governance in companies with state participation in the energy sector set forth in the Civil Code recommended by the Central Bank of the Russian Federation as private and integral part. As for the next question of special corporate rights, the proposed unification should further differentiate these rights from the respective entity and divide them into special corporate rights inherent not only in the state party, but special corporate rights inherent in all participants in the corporate relations. Clear identification of such rights will also allow us to formulate provisions on responsibility made by authorized government bodies. Next question on local normative acts. I'd like to say that the local normative acts within the framework of the study are understood as internal documents according to paragraph 5, Article 52 of the Civil Code. Indeed, Article 92 of the Federal Law on Joint Stock Companies enshrines the obligation of joint stock companies to disclose information about internal documents in accordance with the procedure established by the Central Bank. At the same time, these requirements are not universal, because they are applied only to a limited number of subjects, such as public joint stock, non-public joint stock companies with more than 50 shareholders, non-public joint stock companies which carry out public offering, bonds or other securities. Thus, for non-public joint stock companies and limited liability companies, which are also represented among companies with state participation in the energy sector, as a general rule, there are no special requirements for disclosure of information about internal documents. Such suggested requirements will improve the mechanism established by central bank in the energy sector, subject to the federal law on joint stock companies, and will ensure information disclosure of non-public joint stock companies. And the next question was about broad representation, provision number 9, and their responsibility. I'd like to say that in the second paragraph of second chapter, we look at guaranteed representation of various organizations in combination with members of such bodies. I talk about this on page 108. A set of these measures shall fully implement the principle of professionalism. At the same time, issues of legal responsibility of members of the supervisory board will have a special political and legal specificity and will require a further study in the theory of energy law. As for the last question on the name of the internal audit body and audit commission of public joint stock company as a body or legal entity, it should be noted that in this research, internal audit commission of business entities considered a specialized control body that is not a declaring entity and does not correspond to the general concept of a body or legal entity within the meaning of Article 23 of the Civil Code. The structural subdivision of Rosatom internal audit was also regarded as an independent control body, since it is a separate entity with special powers. To determine the reliable results of the research, these bodies are regarded as participants in the corporate legal regulations. And in conclusion, I would like to thank Olga Alexandrovna once again for the positive assessment of the work and for her interesting questions for discussion. Also, I'd like to thank Director for Legal and Corporate Affairs and Property Complex of Rosatom State Corporation, Popov Andrey Vladimirovich, for his external review with positive assessment. Since the questions are similar, I have already answered when answering the question of Lyubov Ivanna Shevchenko, so I will not repeat my answer with your permission. As for the second question about experience of provision number 8, taking into account the rights and obligations of various participants of social relations in the nuclear industry, I'd like to say that this federal law establishes some general rights of citizens and organizations in the field of atomic nuclear energy use. The right to participate in public discussions of certain issues, the right to receive information about activities in the field of nuclear energy use, etc. However, these proposals are aimed exactly at improving efficiency of management by improving the system of the supreme body of the key subject at the expense of balance members of such body. Thus, this proposal seems expedient, since they are oriented towards improving quality of management of state corporations. Once again, I would like to express my sincere gratitude to all members of the Decision Council and the Council Chairman, external reviewer, for questions and positive assessment of my work. Thank you. Thank you, Nikolay Andreyevich. Since we don't have any guests, I don't expect any questions from the public. We have not received any questions by email. That is why I would like to give the floor to the academic advisor. Dear Victoria Varyevna, please remember the time limit, and please tell us about the work of the applicant. Dear Olga Alexandrovna, once again I would like to greet all the council members and express my sincere gratitude for joining us in such hard times and participate in today's discussion of the thesis by Nikolay Andreyevich Akimov. Nikolay Andreyevich joined our department some time ago. He started with a corporate law department, and so he asked for permission to be transferred to our department, so we started working together, and this work was very interesting for me, and I enjoyed it greatly. Nikolay Alexandrovich participated in all the activities organized by our department, took part in scientific and practical activities which involved representatives of state, partly of companies partly owned by the state, such as representatives of Rosatom, Gazprom, and other energy companies, network companies, and the Market Council. The questions set by Nikolay Andreyevich, to which he tried to obtain answers, they deserve great attention, and they all can become subjects for separate studies. These issues are complex and are now very much discussed by the scientific community. That is because it's hard to ensure the balance of interests between the objectives set by partly state-owned companies and their commercial interests. So here we considered interesting opinions of our German colleagues, who suggest that when discussing socially significant issues such as support to the energy set, I define such objectives as primary and consider commercial goals to be secondary. So Nikolay Alexandrovich considered different models from the nuclear and gas industry, compared them, and I think that will be interesting in the future. Today, the only legislator does not exclude, but in our situation with Russian energy companies, is a state corporation, very well structured, or there will be certain limits, which is now true for gas industry, electricity and oil industries. And I would like once again to thank all the members of the Dissertation Council, external reviewer, for their positive assessment of the work and for their very interesting questions and recommendations they have given. Thank you very much for devoting your time and supporting. And I would like to wish to Nikolay Andreyevich lots of success, and I hope he will continue his work. Thank you very much. Thank you, Victoria Valerievna. I have two questions to the council members and to the degree applicants. Since most council members are working in the remote access mode, do you have any questions regarding the procedure, the remote access mode? If you have no questions, let us proceed to the next point. My next question. Now we have the opportunity, before we vote, to take a break to discuss the results of today's defense, and the sound shall be switched off for this period. Is there a need for such a discussion? I would like to hear each council member. What do you think? Vladimir Fedorovich, do we need such a break? No, we don't, because all the reviewers supported this work, and I think Rosa Nailevna, is there a need to discuss today's defense once again? I support what was said by Vladimir Fedorovich. I think in our reviews we expressed our opinions, our honest opinions, so we don't have any additional questions. Lyubov Ivanovna, no, I don't think we need such a discussion. Dr. Taulus, what is your opinion? Do we need any private discussion?
No.
Dr. Raphael Heffron, do we need a private discussion?
No, we don't.
Thank you, everybody. Then let us vote. Let us proceed to the final and the most important part of our session. I put a question of awarding to Akimov Nikolay Andreyevich, degree of candidate of law, specialty 12-0007, corporate law, competitive law and energy law, to the open individual vote. Let me remind you that a decision of the Decision Council on awarding degree shall be considered positive if more than a half, but at least three members of the Decision Council present at the meeting voted for it, according to Article 23 of the Order. That is why I will ask each council member individually for their opinions. Council member Dr. Papandopoulou Vladimir Fedorovich, your opinion? I am for awarding the degree. Thank you. Council member Dr. Rosa Nailevna Saliva, your opinion? I am for awarding, and I think the applicant should be awarded the degree. Thank you. Council member Shevchenko Lyubov Ivanovna, I am for awarding the degree. Council member Dr. Taulus, unfortunately you don't have the right to vote. What shame. And council member Dr. Raphael Heffron, your opinion, please.
I am in favor of awarding the degree.
Thank you. I, chairman of the council, Makarova Olga Alexandrovna, for awarding the degree of candidate of law. Thus, dear colleagues and guests, let me announce that out of 5 council members who voted. 5 voted for awarding the degree, no one voted against, and no one abstained. Thus, the decision to award to Akimov Nikolay Andreyevich the scientific degree of Candidate of Law, Specialty 12-0007, Corporate Law, Comparative Law and Energy Law, has been made. Dear colleagues, since some council members are working in remote access mode, do council members or the applicant or anyone present have any comments on the procedure of today's session? Council members, do you have any comments regarding the procedure? Vladimir Fedorovich, please. No, I don't have any comments. Rosa Nailevna Saileva, do you have any comments regarding the procedure? No, I don't. Lubov Ivanina Shevchenko, no comments. Dr. Taulus, any comments regarding the procedure of today's session?
No comments. Apologies for being late.
К сожалению, технически вы чуть-чуть позже подсоединились. Доктор Рафаэль.
Dr. Raphael Hafran, do you have any comments regarding the procedure?
No comments.
Так, спасибо.
Thank you. Then I have to give the floor to the applicant for his closing remarks. Nikolay Andreyevich, the floor is yours. Dear Chairman of the Council, dear Council members, for me that's an honor that the Dissertation Council, who discussed my work, includes such distinguished experts on energy law, and I will, in the future, I will try to live up to your expectations. I would like to thank all the members of the Dissertation Council for their valuable recommendations and positive assessment of my work. Also, I'd like to thank all the members of the Dissertation Council for participating in this session in our hard times, and for our foreign colleagues for finding time and taking part, being so far away. And thank you for paying attention to my work and giving your time to this session. Also, I'd like to thank one person without whom my research would not be successful, my academic advisor, who guided me, who provided valuable recommendations, criticized me sometimes, and I would like to say many thanks to her. Also, I'd like to thank my wife, my parents, and my family, my close friends, who supported me during the entire process and supported me in my work. Also, I would like to thank Dissertation Council Activity Support Department in these hard times for their support in handling all the necessary formalities. Thank you. And in conclusion, I would like to wish to everyone present here health and well-being in our hard times, the time of the pandemic. Thank you. Nikolay Andreyevich, thank you. And on behalf of the Dissertation Council members, I'd like to congratulate you on defending your thesis successfully. We wish you future success in your scientific career, and I declare the session closed. I thank all the members working in the remote access mode. Thank you for your participation, and please stop online broadcasting. Thank you.